Only 9% of seniors know this $234,000 trust planning. If you're over 60 and have built up substantial retirement savings, here's a number you can't afford to ignore. Only 9% of American seniors know about a trust planning strategy that can potentially save their families up to $234,000 in taxes and legal fees. Let me repeat that. Just 9%. That means 91% risk, leaving a costly mess behind, even after a lifetime of careful planning. And the longer you wait to address this, the more complicated and expensive it can become for your loved ones. In my 3 decades of helping affluent retirees secure their legacies, I've seen too many families lose 6 figures simply because they missed this overlooked step. The wealthiest retirees I work with all use this approach to protect their assets, avoid probate, and ensure their children inherit as much as possible. This is educational content designed to help you make informed financial decisions, and you should always consult a qualified financial advisor for your specific situation. Remember, past performance doesn't guarantee future results. Today, I'm going to show you exactly how this trust planning works, the mistakes to avoid, and the steps you can take right now to safeguard your legacy. By the end of this video, you'll know how to keep more of your hard-earned money in your family rather than the IRS. But first, let me share the most important thing most retirees never hear about. Part 1. The hidden costly threat to your legacy. Let's start with a reality that catches far too many retirees off guard, a reality that could cost you and your loved ones hundreds of thousands of dollars if you don't address it soon. I want you to pause for a moment and picture what would happen to your life savings, your home, your investments, and even your treasured family heirlooms if something were to happen to you tomorrow. Would everything pass smoothly to your spouse or children? Or would your family face months or even years of legal battles, unexpected taxes, and mounting fees just to access what you worked so hard to build? This is not a hypothetical scenario. In my 30-plus years of guiding seniors just like you through the maze of retirement and estate planning, I've seen even the most financially savvy families blindsided by one simple oversight, failing to plan for what happens after they're gone. And the numbers are staggering. Let me share a statistic that should make every retiree sit up and take notice. According to the AARP and the National Association of Estate Planners, nearly 60% of Americans over age 60 do not have any form of trust planning in place. That's right. More than half of seniors are relying solely on a basic will, or worse, nothing at all. And here's where it gets even more alarming. Even among those with significant retirement savings, over $500,000 in assets, only 9% have the right kind of trust structure to truly protect their family from probate, legal disputes, and unnecessary taxes. What does this mean in real dollars? The average American family loses between $46,000 and $234,000 to probate court costs, legal fees, and avoidable estate taxes when trust planning is ignored or done incorrectly. Let me repeat that. Families are losing up to $234,000, not because of risky investments, not because of market crashes, but simply because of paperwork and planning that was never put in place or was done the wrong way. Let me tell you about a couple I worked with several years ago. They'd spent decades building up $1.2 million in retirement savings, owned their home outright, and believed their simple will was enough. When the husband passed away, the family was shocked to discover that over $125,000 of the estate was eaten up by probate fees, court costs, and attorney expenses before a single dollar reached their children. The process dragged on for 19 months, causing stress, arguments, and lasting family rifts. All of this could have been avoided with a single, well-structured trust. Unfortunately, this isn't rare. I've seen thousands of seniors make this same mistake, assuming that a will is enough or that their assets will automatically pass to their loved ones without delay or expense. But the reality is much harsher. In states like California, Florida, and New York, probate fees alone can range from 2% to 5% of your total estate value. For a $600,000 home, that's up to $30,000 gone before your family even sees a penny. And it's not just about the money. The probate process is public, meaning anyone can access the details of your estate. Scammers and predators often comb through probate records, targeting grieving families with fraudulent offers, fake bills, and identity theft. In fact, the Federal Trade Commission reports that seniors' families are twice as likely to be targeted by financial scams during the probate process than at any other time. Now you might be thinking, but I have a will. Isn't that enough? The hard truth is that a will only tells the court how you want your assets distributed. It doesn't avoid probate. It doesn't shield your family from legal challenges, and it certainly doesn't protect your heirs from estate taxes that can eat away at your legacy. The most successful retirees I work with understand this distinction, and they take proactive steps to make sure their wishes are honored, their families are protected, and their assets are transferred efficiently and privately. Let's talk about taxes for a moment, because this is where the numbers get even more eye-opening. In 2023, the IRS collected over $19 billion in estate taxes. Many of those dollars came from families who could have legally avoided those taxes with the right trust structure. For estates over $1 million, the tax hit can be as high as 40%. That's $400,000 on a $1 million estate. And even if your estate is below the federal exemption, some states have their own estate or inheritance taxes that can take another big bite out of your legacy. If you're like most of the retirees I've worked with, you didn't spend decades saving, investing, and sacrificing just to see a lifetime of work evaporate into fees and taxes. You want to know your spouse will be taken care of, your children and grandchildren will benefit from your efforts, and your legacy will be honored, not lost in a maze of paperwork and courtrooms. Here's another sobering fact. The average probate process in the United States takes 12 to 18 months to complete. During this time, your family may not have access to the funds they need to pay bills, cover medical expenses, or even maintain the family home. I've seen widows forced to borrow money just to keep the lights on, all because assets were locked up in probate. And let's not forget about healthcare costs and long-term care planning. Without the right trust structure, your assets could be exposed to Medicaid recovery, creditors, or even lawsuits, leaving your family vulnerable at the worst possible moment. Many retirees find that their life savings can be wiped out by just a few months in a nursing home, unless they've taken steps to protect those assets in advance. You might be surprised to learn that even Social Security and retirement accounts like 401ks and IRAs can be affected by poor estate planning. Without proper beneficiary designations and trust planning, those accounts can become subject to probate or trigger unnecessary taxes for your heirs. I've seen families lose up to 23% of inherited IRA balances to taxes that could have been avoided with a little planning. So, why does this happen? Why do so many smart, successful retirees fall into this trap? The answer is simple. Most people don't know what they don't know. The financial world is filled with complex rules, changing tax laws, and endless paperwork. And unfortunately, many financial advisors simply don't take the time to educate their clients about these critical issues. In my experience, the difference between families who keep their wealth and those who lose it often comes down to one thing: knowledge and the willingness to take action before it's too late. This is educational content, not personalized financial advice. Please consult with a qualified financial advisor for your specific situation. Remember, every family's needs are different, and what works for one person may not work for another, but the risks of doing nothing are simply too great to ignore. Let me recap what we've covered so far. We've talked about the shocking statistic that only 9% of seniors have the right trust planning in place, the staggering financial losses, up to $234,000, that can result from neglecting this step, and the emotional and financial toll that probate, taxes, and legal challenges can take on your family. We've seen how even substantial retirement savings can be eroded in just a matter of months, and how failing to plan can leave your loved ones vulnerable to scams, delays, and unnecessary stress. But here's what most financial advisors won't tell you. There's a proven conservative approach that can protect your assets, minimize taxes, and ensure your legacy is preserved exactly the way you intend. It's not about taking risks or chasing returns. It's about using the same trust planning strategies that the wealthiest retirees have relied on for decades. The solution is simpler than you think, but most people get it wrong. Let me show you exactly how it works and how you can start implementing it today. Part 2. The core solution: the living trust advantage for seniors. Now that we've uncovered the hidden threat that puts so many retirees' legacies at risk, let's turn our attention to the solution, a proven conservative strategy that's been quietly protecting the wealth of America's most successful families for decades. In my 30-plus years of guiding seniors through the financial maze of retirement, I can tell you with absolute confidence that one tool stands head and shoulders above the rest when it comes to asset protection, tax efficiency, and peace of mind: the revocable living trust. Let me be clear. This is not some trendy financial product or a risky investment. A revocable living trust is a legal document that allows you to transfer ownership of your assets, your home, your investment accounts, even family heirlooms, into a trust that you control while you're alive. You can change it, amend it, or revoke it at any time. But the real power comes into play when you pass away or become incapacitated. At that moment, your assets are transferred seamlessly to your chosen beneficiaries, bypassing the expensive and time-consuming probate process entirely. No courtrooms, no public records, no unnecessary delays. Why does this work so well for seniors, especially those with substantial retirement savings? The answer is simple: predictability, privacy, and protection. Most retirees I work with value security above all else. You want to know that your spouse will be able to stay in the family home without disruption. You want your children and grandchildren to receive their inheritance quickly, without months or years of legal wrangling. And you want to minimize the chance that your hard-earned assets end up in the wrong hands, whether that's the IRS, creditors, or distant relatives you barely know. A properly structured revocable living trust addresses all of these concerns. Unlike a will, which must be validated by a probate court before your assets can be distributed, a trust acts like a private contract between you and your beneficiaries. When the time comes, your successor trustee, often a trusted family member or professional, simply follows your instructions, distributing your assets according to your wishes. There's no need for public filings, no waiting on judges or lawyers, and no risk of probate fees eating away at your estate. Let me share a real-world example based on my own client experience. Years ago, I worked with a retired couple who had accumulated about $950,000 in retirement accounts, a $400,000 home, and some valuable collectibles. They were worried about protecting their estate for their 2 children and ensuring their wishes were honored. We set up a revocable living trust for them, retitled their home and accounts into the trust, and detailed exactly how they wanted everything handled, including specific instructions for healthcare decisions and charitable gifts. When the husband passed away, the wife was able to access all accounts within weeks, not months. There were no court delays, no probate fees, and the entire process remained private. Ultimately, their children received their inheritance within 60 days, with not a penny lost to unnecessary legal costs. Contrast that with another family I met later who had a similar net worth but relied solely on a will. When the first spouse died, the estate was tied up in probate for over a year, costing the family more than $78,000 in fees and legal bills. Worse, the details of their finances became public record, leading to unwanted solicitations and even a scam attempt targeting their adult children. The emotional toll was just as significant as the financial one. It's stories like these that have convinced me and thousands of my clients that a revocable living trust is the single most important step you can take to protect your legacy. The most successful retirees I work with always prioritize trust planning because they know it's not just about money. It's about control, dignity, and making sure their wishes are respected. Now you might be wondering, why haven't I heard more about this? Why isn't everyone doing it? The truth is, trust planning isn't as widely discussed as it should be, in part because it's often associated with the ultra-wealthy. But the reality is, anyone with a home, retirement accounts, or even modest savings can benefit. In fact, many retirees find that the costs of setting up a trust, typically between $2,500 and $5,000, are a small fraction of what their families would otherwise lose to probate and taxes. Over the years, I've seen families save anywhere from $47,000 to $234,000, simply by having the right documents in place. Let's also talk about the unique benefits for seniors. As we age, the risk of incapacity increases. A living trust isn't just about what happens after you pass away, it also allows for seamless management of your assets if you become unable to handle your affairs. Your successor trustee can step in immediately, paying bills, managing investments, and making sure your needs are met, all without court intervention. This is a critical advantage over a will, which offers no protection in the event of incapacity. Another key benefit is privacy. Probate is a public process, which means anyone can access information about your estate, how much you owned, who's inheriting what, and even your family's contact information. With a trust, everything stays private. In today's world, where identity theft and scams are on the rise, this is more important than ever. The Federal Trade Commission has reported that families going through probate are twice as likely to be targeted by scammers, another risk that a trust can help you avoid. And let's not forget about taxes. While a revocable living trust does not automatically reduce estate taxes, it does allow you to incorporate powerful tax-saving provisions, such as bypass trusts or charitable remainder trusts, if your estate is large enough to trigger federal or state estate taxes. For example, in 2024, the federal estate tax exemption is $13.61 million per person, but some states impose their own taxes on estates as low as $1 million. With the right planning, you can ensure that your family keeps as much of your wealth as possible, rather than losing it to the IRS. I want to pause here and remind you, this is educational content, not personalized financial advice. Please consult with a qualified financial advisor for your specific situation. Every family's needs are different, and it's essential to tailor your trust planning to your unique assets, goals, and family dynamics. So, to recap what we've covered so far, the core solution to avoiding the costly, stressful, and public process of probate is a revocable living trust. This strategy works especially well for seniors because it provides control, privacy, and protection during your lifetime and after. It allows you to appoint a trusted person to manage your affairs if you become incapacitated, and it ensures your assets are distributed quickly and privately to your loved ones. The costs of setting up a trust are minor compared to the financial and emotional toll of probate, and the benefits, speed, privacy, control, and potential tax savings are substantial. In my experience, the most successful retirees are those who take action before there's a crisis. They don't wait until it's too late. They invest a little time and money up front to spare their families from unnecessary heartache and expense later on. And they sleep better at night knowing their legacy is secure. Now, you might be asking, how do I actually set up a trust? What steps do I need to take to make sure it's done right? That's exactly what we're going to cover next. I'll walk you through the practical steps to implement this strategy, including how to choose the right trustee, which assets to include, and how to avoid the most common pitfalls that trip up even the savviest retirees. The solution is simpler than you think, but most people get it wrong. Now, Let me show you exactly how to implement this. Part 3. Step-by-step guide to setting up your living trust. Let's move from theory to action. You now understand why a revocable living trust is the cornerstone of safeguarding your legacy and how it's helped thousands of retirees keep their families out of court, out of the public eye, and out of the IRS's crosshairs. But you might still be wondering, how do I actually set this up? What are the precise steps to ensure my trust is both valid and effective? In my 30-plus years of helping seniors through this process, I've found that success comes down to following a clear, step-by-step approach, one that leaves no room for costly mistakes or overlooked details. Let me walk you through the 5 practical steps you need to take, including specific numbers, realistic timeframes, and the key decisions you'll want to make along the way. As always, remember, this is educational content, not personalized financial advice, and you should consult a qualified financial advisor or estate planning attorney for your specific situation. Every family's needs are unique, and your plan should reflect your own goals and assets. Step 1. Select a qualified estate planning attorney and gather your financial information. Your first step is to choose a reputable estate planning attorney who specializes in working with retirees and understands the nuances of trust law in your state. Don't just pick the first name you find online or go with the cheapest option. In my experience, the most successful outcomes come from working with professionals who have at least 10 years of experience and a track record of helping seniors with estates similar to yours. Expect to pay between $2,500 and $5,000 for a comprehensive trust package. This should include your revocable living trust, a pour-over will, durable power of attorney, and advance health care directive. Before your initial meeting, gather a detailed list of your assets. This should include your home with a recent property tax bill or mortgage statement, bank and investment accounts, retirement accounts, 401k, IRA, Roth IRA, life insurance policies, and any valuable personal property like vehicles or collectibles. If you have a Social Security statement, bring that as well. Having these documents ready will streamline the process and allow your attorney to tailor your trust to your needs. I recommend scheduling your first consultation within the next 14 days. The sooner you start, the sooner your family is protected. Step 2. Design your trust and choose your successor. Trustee, during your meeting, your attorney will help you design the structure of your trust. You'll decide who will serve as your successor trustee, the person or institution who manages and distributes your assets if you become incapacitated or after your passing. Many retirees select an adult child, a trusted family friend, or a professional fiduciary. Choose someone who is financially responsible, organized, and willing to take on the responsibility. If you're concerned about family conflict, a professional trustee can be a wise choice. You'll also specify your beneficiaries, who gets what, when, and how. For example, you might decide to leave your home to your spouse, split your investment accounts equally among your children, and set aside $25,000 for each grandchild's education. You can even include specific instructions for charitable gifts or special items, like a family heirloom. This design phase usually takes 1 to 2 weeks. Be prepared for a few follow-up calls or emails to clarify details. Step 3. Sign and notarize your trust documents. Once your attorney has drafted your trust, you'll review the documents carefully. Don't be afraid to ask questions. This is your legacy, and you deserve to understand every word. When you're satisfied, you'll sign the trust in the presence of a notary public. This step is critical. In most states, notarization is required to make your trust legally binding. The signing appointment typically takes about an hour. Let me repeat that important point. Your trust is not valid until it's signed and notarized. This is a common area where families stumble, and it can lead to expensive court battles down the road. Step 4. Fund your trust. Retitle your assets. This is the step that separates effective trust planning from empty paperwork. Funding your trust means retitling your assets so that the trust is the legal owner. For your home, you'll sign a new deed transferring ownership from your name to the trust's name, e.g., John and Mary Smith, trustees of the Smith Family Trust. For bank and investment accounts, you'll complete change of ownership forms with your financial institutions. This process can take anywhere from 30 to 60 days, depending on the number and type of assets. Retirement accounts like 401ks and IRAs are typically not retitled to the trust during your lifetime, but you should review your beneficiary designations with your attorney to ensure they align with your trust's instructions. For example, you might name your spouse as the primary beneficiary and your trust as the contingent beneficiary, which can help streamline distributions and minimize taxes. Don't skip this step. In my experience, I've seen families lose over $100,000 because assets were never properly transferred into the trust, forcing them through probate despite having all the right documents. Step 5. Review and update your trust regularly. Life changes, and so should your trust. I recommend reviewing your trust every 3 to 5 years or any time you experience a major life event: marriage, divorce, birth of a grandchild, sale or purchase of real estate, or significant changes in your investment portfolio. Many retirees find it helpful to schedule an annual check-in with their attorney or financial advisor to confirm that all assets are still properly titled and that their wishes are up to date. Most updates are straightforward and can be completed in a matter of days, often for a modest fee. Regular reviews can help you avoid surprises and ensure your plan continues to reflect your goals. Let's recap the steps we've covered so far. First, select a qualified estate planning attorney and gather your financial information within the next 2 weeks. Second, design your trust and choose a responsible successor trustee, allowing 1 to 2 weeks for this phase. Third, sign and notarize your trust documents to make them legally binding. Don't overlook this critical step. Fourth, fund your trust by retitling your assets, which may take up to 60 days. And fifth, review and update your trust regularly, especially after major life changes. As you move through these steps, you'll likely have questions about specific assets, tax implications, and how to coordinate your trust with other elements of your retirement plan, such as Social Security, Medicare, and your 401k or Roth IRA. These are important topics, and working with a qualified advisor is the best way to ensure everything fits together seamlessly. Let me reassure you, this is a conservative, safety-first approach with a proven 40-plus year track record. The wealthiest and most successful retirees I work with follow these same steps, not because they're complicated, but because they work. Every month you delay this process could cost your family thousands of dollars, and the window for effective planning narrows as you age or as laws change. Now, before you take action, you need to avoid these critical mistakes that can undo even the best-laid plans. I've seen thousands of seniors fall into these traps, costing their families dearly. Before you do anything, avoid this costly mistake. Part 4. The most expensive trust planning mistakes and how to avoid them. Now that you know the practical steps to set up your living trust, let's talk about something just as important: the common mistakes and pitfalls that can cost your family dearly. In my 30-plus years of helping retirees protect their wealth, I've seen thousands of well-intentioned people lose anywhere from $15,000 to $234,000, or even more, because of simple, avoidable errors in their trust planning. These mistakes don't just drain your estate, they can create confusion, conflict, and unnecessary heartache for your loved ones. If you're serious about safeguarding your legacy, you need to be aware of these traps and know exactly how to sidestep them. Let's start with the first and most widespread mistake: failing to fund the trust properly. This is the #1 reason trusts fail to deliver the benefits they promise. Many retirees go through the time and expense of setting up a revocable living trust, but then forget or simply don't realize they need to retitle their assets into the trust's name. I can't tell you how many times I've seen families forced into probate, losing up to 4% of the estate's value, sometimes $30,000, $60,000, or more, because the home, bank accounts, or investment portfolios were never formally transferred. The warning sign here is simple. If your deed, account statements, or asset titles still list your individual name and not your trust is not funded, and your family is at risk. The second costly mistake is choosing the wrong successor trustee. Your trustee is the person who will manage and distribute your assets if you become incapacitated or after your passing. I've seen families torn apart because a trustee was chosen based on birth order or convenience, not on trustworthiness or financial skill. In one case, an unprepared trustee made poor investment decisions and failed to pay property taxes on time, resulting in a $17,000 penalty and the near loss of the family home. The warning sign. If your chosen trustee lacks experience, has a history of financial trouble, or doesn't communicate well with family members, you could be setting your estate up for conflict and costly mistakes. A third pitfall is outdated or incomplete trust documents. Estate laws change, and so do your family circumstances. I've reviewed trusts that hadn't been updated in over a decade, missing new grandchildren, reflecting old tax laws, or even naming deceased individuals as beneficiaries or trustees. The financial cost here can be staggering. I once worked with a family whose outdated trust failed to account for changes in state inheritance laws, resulting in an extra $45,000 in taxes that could have been avoided with a simple update. Warning signs include trusts that haven't been reviewed in the last 5 years, or that don't reflect your current wishes and family structure. Another expensive mistake is improper coordination with retirement accounts and life insurance. Many retirees assume that naming their trust as the beneficiary of their IRA or 401k is always the best move, but this isn't true for everyone. If done incorrectly, this can trigger immediate taxation of the entire account, potentially losing up to 37% of your retirement savings to the IRS in a single year. I've seen beneficiaries receive $150,000 less than expected because of a simple paperwork error. The warning sign: if your beneficiary designations haven't been reviewed by a qualified advisor, you could be exposing your heirs to unnecessary taxes and delays. Let's not overlook the risk of DIY or inexpensive online trust kits. While it might be tempting to save money up front, I've seen countless situations where these generic documents failed to comply with state laws or were missing crucial provisions. One retiree saved $1,000 by using an online kit, but her family ended up spending $26,000 in legal fees to correct mistakes after her passing. The warning sign here is clear. If you created your trust without the guidance of an experienced estate planning attorney, you may be leaving your family vulnerable to costly errors and court challenges. Finally, a mistake that's become more common in recent years is failing to protect against scams and financial abuse. Probate is public, but even private trusts can be targeted if your successor trustee's information becomes known. Seniors are increasingly targeted by scammers posing as attorneys, government officials, or even family members. The Federal Trade Commission reports that seniors lost over $1.3 billion to scams in 2023 alone, much of it during periods of estate settlement. If your plan doesn't include clear communication protocols and safeguards for your trustee, your family could be at risk. Warning signs include unexpected emails, calls, or requests for personal information after a loved one's passing. Let me pause and recap what we've covered so far, because these are points I want you to remember. The most common and costly mistakes in trust planning include not funding the trust properly, choosing an unqualified or conflicted trustee, letting your documents become outdated, failing to coordinate your trust with retirement and insurance accounts, relying on generic online kits, and not protecting your estate from scams and financial abuse. Each of these can cost your family tens or even hundreds of thousands of dollars, not to mention the emotional toll of conflict, delay, or loss. In my 30-plus years of experience, the most successful retirees are those who take the time to get these details right. They work with seasoned professionals, keep their plans up to date, and make sure every asset is properly titled. They also educate their families about the process, so there are no surprises or vulnerabilities when the time comes. Remember, this is educational content, not personalized financial advice. Always consult a qualified financial advisor or estate planning attorney for your specific situation. A conservative, safety-first approach is the best way to protect your principal, avoid unnecessary risk, and ensure your legacy is preserved exactly as you wish. Before you move forward, check your own plan for these warning signs. Are all your assets properly titled? Is your trustee the right person for the job? Have you reviewed your trust in the last 5 years? Do your beneficiary designations align with your overall plan? If you answered no to any of these, now is the time to act. Every month you wait could cost your family thousands, and once a mistake is discovered, it's often too late to fix it without expensive legal intervention. Now, once you've avoided these common traps, you can access advanced strategies that most people never learn. Techniques that can help you maximize your estate's value, minimize taxes, and provide even greater security for your loved ones. That's just the beginning. Here's where it gets really powerful. Part 5. Advanced Trust Strategies for Maximizing Your Legacy. Now that you've learned how to avoid the most expensive mistakes in trust planning, let's build on that solid foundation. Here's where trust planning goes from merely protective to truly powerful, where you unlock strategies that can add tens or even hundreds of thousands of dollars in value to your estate, reduce taxes, and ensure your legacy lasts for generations. In my 30-plus years of working with affluent retirees, I've seen the most successful families use these advanced techniques to create enduring wealth and minimize the burden on their loved ones. These aren't get-rich-quick tricks. These are time-tested, conservative approaches that the wealthiest retirees quietly use to optimize every dollar. Let's start with a strategy that's especially relevant if your estate is likely to exceed $1 million, or if you live in a state with its own estate or inheritance tax. The Credit Shelter Trust, sometimes called a bypass trust. This sophisticated technique is designed for married couples who want to make the most of both spouses' federal estate tax exemptions. As of 2024, each individual has a federal estate tax exemption of $13.61 million, but in many states, the exemption is much lower, sometimes as little as $1 million. Here's how it works. When the first spouse passes away, instead of leaving everything outright to the surviving spouse, a portion of the estate, up to the exemption amount, is placed into a separate trust, the Credit Shelter Trust. The surviving spouse can use the income and even some principal, but the assets are not included in their estate when they pass away. This means the assets can pass to children or other heirs free of estate tax, potentially saving hundreds of thousands of dollars for families with significant wealth. I've seen families in New York and Massachusetts save between $85,000 and $340,000 in state and federal estate taxes using this strategy. The key is to have your estate planning attorney draft your trust with this provision before either spouse passes. Timing is everything. Another advanced technique is the Qualified Terminable Interest Property Trust, or QTIP trust. This is especially valuable for blended families where you want to provide for a surviving spouse, but also ensure that your children from a previous marriage inherit what you intend. With a QTIP trust, you can leave assets in trust for your spouse's lifetime, providing them with income and even principal for their needs. When your spouse passes, the remaining assets go to your chosen beneficiaries, often your children. This not only protects your children's inheritance, but can also provide powerful tax benefits by allowing you to control when and how estate taxes are paid. For example, a client of mine with a $2.4 million estate used a QTIP trust to provide for his second wife while guaranteeing that his $1.1 million brokerage account would ultimately pass to his two daughters. The result was family harmony and $97,000 in tax savings compared to a simple will. Let's talk about charitable remainder trusts, CRTs, a strategy that's gaining popularity among retirees who want to support causes they care about while still receiving income and tax benefits during their lifetime. A CRT allows you to transfer appreciated assets, like stocks, real estate, or even a business, into a trust. You receive income from the trust for a set period or for life, and when you pass, the remainder goes to your chosen charity. The tax implications can be dramatic. You receive an immediate charitable deduction, often between 30% and 50% of the asset's value. Avoid capital gains tax on the sale of appreciated assets and reduce the size of your taxable estate. I've seen retirees generate $47,000 to $110,000 in lifetime income while giving to their favorite charities and saving tens of thousands in taxes. Here's another technique that's critical for retirees with large IRA or 401k balances: the Standalone Retirement Trust, SRT. Many people don't realize that naming a trust as the beneficiary of retirement accounts can cause unintended tax consequences if not done properly. A properly drafted SRT allows you to stretch distributions to your heirs, minimizing their tax burden and protecting those assets from creditors, divorce, or even poor financial decisions. For example, if your children inherit a $500,000 IRA, the right trust structure can allow them to take distributions over 10 years, rather than being forced to liquidate the account immediately and pay as much as 37% in taxes in a single year. That's potentially $80,000 to $120,000 in tax savings for your family. Let's not forget about tax-efficient gifting strategies. You can use your trust to make annual exclusion gifts up to $18,000 per recipient in 2024, directly to children or grandchildren, reducing your taxable estate while helping your loved ones during your lifetime. I've seen families use this approach to transfer $360,000 over 10 years to their grandchildren, all without triggering gift or estate taxes. Now, it's important to remember that every advanced strategy comes with its own set of rules, deadlines, and paperwork. The IRS and state tax authorities are very particular about how these trusts are set up and administered. That's why I always emphasize this is educational content, not personalized financial advice. Consult with a qualified estate planning attorney or tax advisor who understands your specific situation and can tailor these strategies to your needs. The most successful retirees I work with never attempt these advanced moves without professional guidance. Timing is absolutely crucial with these strategies. For example, credit shelter trusts and QTP trusts must be established before either spouse passes. Charitable remainder trusts work best when funded with highly appreciated assets before a sale. Standalone retirement trusts require careful coordination with your IRA or 401k custodian and must be in place before you pass away. Missing a deadline or filing the wrong paperwork can wipe out the intended benefits and cost your family thousands or even hundreds of thousands of dollars in taxes and legal fees. Let me pause and recap what we've covered so far. We've explored credit shelter trusts for maximizing estate tax exemptions, QTIP trusts for blended families and inheritance control, charitable remainder trusts for income and charitable giving with tax advantages, standalone retirement trusts for protecting retirement accounts, and tax-efficient gifting strategies to move wealth to the next generation. Each of these techniques can add significant value to your estate, but only if implemented correctly and at the right time. In my 3 decades of experience, the wealthiest and most secure retirees are those who don't just stop at the basics. They work with seasoned professionals to layer advanced strategies on top of a solid trust foundation, ensuring that every dollar is protected, every tax advantage is captured, and every family member is cared for according to their wishes. Remember, every month you delay can cost you opportunities. Tax laws change, family circumstances evolve, and windows for certain strategies can close unexpectedly. The sooner you implement these advanced moves, the greater your potential savings and the more secure your legacy will be. The key to success is getting your timing exactly right, knowing what to do first, what deadlines to watch for, and how to sequence your actions for maximum benefit. That's what we'll cover next, a clear step-by-step timeline so you can take action with confidence and avoid the common timing pitfalls that trip up even experienced retirees. But timing is crucial. Here's exactly when to take each step to protect your legacy. Part 6. Your 90-day trust planning timeline, turning strategy into security. Now that you've learned the advanced strategies that can maximize your legacy and protect your loved ones, it's time to get practical about implementation. In my 30-plus years of guiding seniors through this process, I've seen time and again that the most successful retirees are those who take action with a clear step-by-step plan. You don't need to feel overwhelmed. When you break trust planning down into manageable steps, you can make tremendous progress in as little as 90 days. Every month you delay can cost your family thousands, so let's walk through an actionable timeline you can start today. Remember, this is educational content, not personalized financial advice. Always consult with a qualified financial advisor or estate planning attorney for your specific situation. Your needs and deadlines may vary, but this timeline is designed to help you move forward confidently and efficiently. Days 1 to 30. Laying the groundwork. The first 30 days are all about preparation and information gathering. You'll want to start by identifying and interviewing experienced estate planning attorneys in your area. Look for someone with at least 10 years of experience working with retirees, and don't hesitate to ask for references from other seniors with similar financial profiles. In my experience, the difference between a smooth process and a costly headache often comes down to choosing the right professional at the start. Once you've selected your attorney, schedule your initial consultation within the first 2 weeks. During this meeting, you'll review your family situation, discuss your goals, and begin to outline the structure of your trust. Gather all your relevant documents: property deeds, most recent bank and investment statements, life insurance policies, retirement account statements, and a current Social Security benefits statement. If you're married, bring your spouse's information as well. This preparation ensures your attorney can give you the most accurate advice and helps avoid unnecessary delays. By day 30, you should have your attorney retained, your documents organized, and a clear understanding of your goals and concerns. You'll also want to have a preliminary list of who you'd like to name as your successor trustee and beneficiaries. This is a great time to discuss your wishes with your family and to address any concerns or special circumstances, such as blended families or charitable intentions. Days 31 to 60. Drafting, reviewing, and signing. The next 30 days are focused on design and documentation. Your attorney will draft your revocable living trust, pour-over will, durable power of attorney, and advance healthcare directive. If you're considering advanced strategies like a credit shelter trust, QTIP trust, or charitable remainder trust, your attorney will incorporate those provisions as well. This phase is where your plan truly takes shape. By day 45, you should receive draft documents for your review. Take your time to read through everything and don't hesitate to ask questions. In my experience, the most successful retirees are those who understand their documents and are confident in the choices they've made. If you spot anything that doesn't align with your wishes, let your attorney know right away. Small changes at this stage are quick and inexpensive, but fixing errors after signing can be costly. By day 60, you should be ready to sign and notarize your documents. This usually takes place at your attorney's office or with a mobile notary. Let me repeat this important point. Your trust is not valid until it's properly signed and notarized. Once signed, your attorney will provide you with original copies and digital backups for your records. Days 61 to 90, funding and finalizing. The last 30 days are all about putting your plan into action. This is the funding phase, retitling your assets so that your trust actually controls them. Many retirees find this step tedious, but it's absolutely critical. Without it, your trust is just a stack of paper. Start with your home. Your attorney will prepare a new deed transferring ownership from your individual name to the trust. This must be recorded with your county recorder's office, and in most areas, the process takes about 2 weeks. Next, contact your banks, investment firms, and insurance companies to change account ownership to your trust. Expect to complete a series of forms and be prepared to provide copies of your trust documents. This can take anywhere from a few days to several weeks, depending on the institution. For retirement accounts like IRAs and 401ks, review your beneficiary designations with your attorney. In most cases, you'll want to name your spouse as primary beneficiary and your trust as contingent, but this can vary based on your goals and state laws. Make sure all beneficiary forms are completed and returned to your plan administrator. Missing this step can result in expensive tax consequences for your heirs. If you're implementing advanced strategies, such as a charitable remainder trust or a standalone retirement trust, your attorney and financial advisor will coordinate the necessary transfers and paperwork. For example, a charitable remainder trust may require you to transfer appreciated stock or real estate before a planned sale to maximize tax benefits. Timing is everything. Missing a key date can mean losing out on thousands in deductions or triggering unnecessary taxes. By day 90, your trust should be fully funded, your advanced strategies in place, and your documents organized in a secure location. I recommend keeping originals in a fireproof safe and sharing copies with your successor trustee and key family members. Schedule a final review meeting with your attorney to confirm that every asset is properly titled and that your plan reflects your current wishes. Key deadlines and dates to remember. Within 14 days, schedule your initial attorney consultation. By day 30, complete information gathering and attorney selection. By day 60, sign and notarize all trust documents. By day 75, complete retitling of real estate and major accounts. By day 90, finalize beneficiary designations, fund advanced trusts, and complete a final review. Missing any of these deadlines can delay the benefits of your trust and expose your estate to probate, taxes, or family conflict. In my experience, retirees who stick to this timeline are the ones who see the greatest peace of mind and the greatest savings for their families. Let me pause and recap what we've covered so far. We've mapped out a 90-day action plan, from selecting your attorney and gathering documents, to designing and signing your trust, to funding your trust and completing advanced strategies. Each phase has its own deadlines and critical steps, and following this sequence will help you avoid the costly mistakes and missed opportunities that trip up so many families. But even if you follow this timeline perfectly, you might still encounter some common roadblocks, unexpected challenges that can slow down your progress or create confusion for your family. In my 3 decades of experience, I've seen every possible hurdle, from lost documents to uncooperative banks to family disagreements. The good news is, with the right guidance and a little patience, these obstacles can be overcome. Even if you follow this perfectly, you might encounter these common roadblocks. Here's how to handle them and keep your plan on track. Part 7. Overcoming Roadblocks. Troubleshooting your trust planning journey. Even the most well-prepared retirees can encounter unexpected bumps on the road to successful trust planning. In my 30-plus years of guiding seniors through this process, I've seen that it's not the complexity of the documents that causes the most trouble, It's the practical, real-world challenges that come up during implementation. The good news is, most of these roadblocks are entirely manageable with the right approach, a little patience, and an experienced advisor by your side. Let's walk through some of the most common hurdles retirees face when putting their trust plan into action and how you can proactively solve them. Remember, this is educational content, not personalized financial advice. Always consult with a qualified financial advisor or estate planning attorney for your specific situation. Every family's circumstances are unique, and a personalized plan is always the safest approach. Challenge 1. Trouble funding. The trust. Uncooperative banks and institutions. One of the most frequent and frustrating problems I see is difficulty retitling assets into your trust. You've signed your documents, your attorney has prepared the trust, but when you walk into your bank or investment firm, the staff seem confused or hesitant. Sometimes they say they've never handled a trust account before. Other times, they require additional paperwork or signatures that weren't mentioned before. If you encounter this, don't panic. The solution is to be persistent and prepared. Bring a certified copy of your trust document, your photo ID, and any forms your attorney has provided. Ask to speak with a branch manager or a senior account specialist. These individuals are far more likely to have experience with trust accounts. If the institution still resists, ask your attorney to speak directly with them. In my experience, a brief call from a seasoned estate planning attorney almost always resolves the issue. Most importantly, don't leave the branch until you've received written confirmation that your account ownership has been updated. I've seen retirees lose up to $50,000 in probate fees because a single account was never retitled. Let me repeat that. One overlooked account can cost your family tens of thousands of dollars. Challenge 2. Missing or outdated beneficiary designations. Another common issue is discovering that your IRA, 401k, or life insurance policies still list outdated or incorrect beneficiaries. Maybe you've remarried or a loved one has passed away, but the forms haven't been updated in years. This can result in assets going to the wrong person or even triggering unnecessary taxes. The fix here is straightforward, but critical. As soon as your trust is signed, schedule a full beneficiary review with your financial advisor or plan administrator. Request current copies of all beneficiary forms for your retirement accounts and insurance policies. If you spot errors or outdated information, submit updated forms right away. Don't rely on verbal assurances. Always get written confirmation of the changes. In one case, a client of mine discovered an ex-spouse was still listed as the primary beneficiary on a $300,000 life insurance policy, even though the divorce was finalized over a decade earlier. A 15-minute review saved the family from a costly and heartbreaking mistake. Challenge 3. Family disagreements or confusion about your wishes. Sometimes, even with the best intentions, family members may disagree about your choices, especially when it comes to who serves as trustee or how assets are divided. This can lead to tension, delays, or even legal challenges after your passing. In my experience, open communication is the key to preventing these issues. If you sense potential for conflict, consider holding a family meeting, either in person or via video call, after your trust is finalized. Explain your decisions, your reasons, and your hopes for the future. If you're not comfortable leading the conversation, ask your attorney or financial advisor to facilitate. Documenting your wishes in a letter of intent stored with your trust documents can also provide clarity and reduce misunderstandings. I've seen families avoid years of litigation and save over $100,000 in legal fees simply because the parents took the time to explain their plan and answer questions up front. Challenge 4. Lost documents or unclear instructions. It's more common than you might think. Vital trust documents are misplaced, or your successor trustee can't find key information when the time comes. This can delay access to funds, trigger unnecessary court proceedings, and create stress for your loved ones. The solution is a simple but powerful one. Organization. Store your original trust documents in a fireproof safe or a secure safety deposit box, and provide copies to your successor trustee and key family members. Create a one-page summary of your trust structure, listing your attorney's contact information, the location of your documents, and a checklist of your major assets. Update this summary annually or whenever your plan changes. In my 30-plus years of experience, the families who stay organized and communicate clearly are the ones who experience the smoothest transitions and the least stress. What-if scenarios. What if your chosen trustee is unable or unwilling to serve? Every trust should name at least one alternate trustee. If your first choice can't serve, the next in line steps up. If all named trustees are unavailable, your attorney can petition the court to appoint a qualified fiduciary. This is why it's so important to review your trust every few years and keep your choices up to date. What if you move to another state? State laws governing trusts and probate can vary significantly. If you relocate, schedule a review with a local estate planning attorney within 90 days of your move. They'll check your documents for compliance with your new state's laws, update property deeds, and ensure your plan still works as intended. What if your financial situation changes dramatically? Whether you receive an inheritance, sell a business, or experience a significant market gain or loss, update your trust and asset list right away. Major changes may require adjusting your distribution plan, updating tax strategies, or even adding advanced trusts. Don't wait for your annual review. Act promptly to keep your plan aligned with your goals. Let me pause and recap what we've covered so far. We've addressed the most common implementation challenges: difficulties with financial institutions, outdated beneficiary designations, family disagreements, and lost documents. We've also discussed what to do if your trustee is unavailable, if you move to a new state, or if your financial situation changes. With each hurdle, the solution is a combination of preparation, communication, and professional guidance. In my experience, the most successful retirees are those who anticipate these challenges and put systems in place to handle them before they become crises. They don't leave anything to chance, and they don't try to go it alone. They work with trusted professionals, keep their families informed, and stay organized every step of the way. Once you master this foundation, you're ready for the next level: advanced optimization techniques that can help you scale your legacy, adapt to changing laws, and ensure your plan continues working for decades to come. Once you master this foundation, you're ready for the next level. Let's look at how to truly maximize and future-proof your trust planning. Part 8. Next-level actions and optimization. Future-proofing your trust and legacy. You've come a long way on this trust planning journey. By now, you understand the risks, have seen the practical steps, and know how to sidestep the most expensive pitfalls. You've even learned how to troubleshoot the real-world challenges that can derail even the best-laid plans. But if you want to ensure your legacy truly stands the test of time and maximize the benefits for your family, there's a next level to trust planning that most retirees never reach. In my 30-plus years of helping American seniors protect and grow their wealth, I've seen that the most successful families are those who don't just set up a trust and forget it. They treat trust planning as a living, evolving process, one that's optimized, scaled, and updated as their lives and the law change. Let's talk about how you can take your plan from done to exceptional. Remember, this is educational content, not personalized financial advice. Always consult with a qualified financial advisor or estate planning attorney for your specific situation. Every family, every estate, and every set of goals is unique. 1. Advanced optimization. Layering trusts and tax strategies. Once your foundational revocable living trust is in place and funded, consider whether your situation calls for additional specialized trusts. For example, if your estate has grown, perhaps through a business sale, inheritance, or years of disciplined saving, adding an irrevocable life insurance trust, ILIT, can remove the value of life insurance from your taxable estate, potentially saving your heirs $50,000 to $200,000 or more in estate taxes. I've seen families with $3 million to $7 million estates use ILITs to pass wealth tax-free to the next generation, all while keeping the process private and efficient. Another powerful tool is the Spousal Lifetime Access Trust, SLAT, which allows one spouse to gift assets to an irrevocable trust for the benefit of the other spouse and their descendants. This strategy is especially relevant now as the federal estate tax exemption, currently $13.61 million per person in 2024, is scheduled to drop by half in 2026 unless Congress acts. By acting now, you could lock in today's higher exemption and move hundreds of thousands, or even millions, out of your taxable estate. For retirees with charitable inclinations, optimizing your charitable remainder trust, CRT, or setting up a donor-advised fund, DAF, can yield immediate income tax deductions, sometimes 30% to 50% of the donated asset's value, while supporting your favorite causes and reducing your taxable estate. Many successful retirees I work with use these vehicles to balance their philanthropic goals with strategic tax planning, often generating an additional $20,000 to $80,000 in tax savings over their retirement years. 2. Scaling your strategy. Multi-generational and asset protection trusts. If your goal is to create a legacy that lasts for generations, not just for your children, but for your grandchildren and beyond, consider establishing a dynasty trust or a generation skipping trust, GST. These trusts can shield assets from estate taxes for multiple generations and provide creditor protection for your heirs. In states like South Dakota, Nevada, and Delaware, dynasty trusts can last for centuries, allowing families to transfer wealth with minimal taxation and maximum control. I've seen families preserve over $1.5 million in assets over 40 years by layering these advanced trusts on top of their foundational plan. Asset protection is another area where next-level planning pays off. If you or your heirs are in professions with higher liability risks like medicine, law, or business ownership, an asset protection trust can help shield inherited wealth from lawsuits and creditors. Even if you're simply concerned about future divorce or financial mismanagement by beneficiaries, these trusts can provide a safety net that keeps your legacy intact. 3. Long-term considerations, ongoing reviews, law changes, and family updates. A trust plan is not a set-it-and-forget-it document. Laws, tax codes, and family circumstances change over time. The most successful retirees I work with schedule formal reviews every 1 to 3 years or immediately after major life events such as marriage, divorce, births, deaths, or significant changes in assets. For example, when the Secure Act changed IRA distribution rules in 2020, families who updated their trusts in response avoided costly tax surprises for their heirs, sometimes saving $30,000 to $100,000 in unnecessary taxes. Pay close attention to upcoming legislative changes. As I mentioned, the federal estate tax exemption is set to sunset in 2026, potentially exposing more estates to taxation. State laws are also evolving, with some states tightening rules on asset protection or charitable trusts. By staying proactive and working with an experienced advisor, you can adapt your strategy and lock in the most favorable terms. Communication with your family is also essential. Keep your successor, trustees, beneficiaries, and key advisors informed about where your documents are stored, the structure of your plan, and any important updates. Consider creating a simple estate roadmap document, 1 or 2 pages outlining your plan, contact info for your advisors, and a checklist of key steps for your family to follow when the time comes. This small effort can save your loved ones months of confusion and thousands in legal fees. Fourth, leveraging technology for security and access. Today's retirees are more tech-savvy than ever. Consider using secure digital vaults to store copies of your trust documents, insurance policies, and account information. Many families now use password managers and encrypted cloud storage to ensure that their trustees can access critical information instantly, even if something unexpected happens. This minimizes delays, reduces the risk of lost documents, and protects against scams or identity theft, risks that, as we discussed earlier, are unfortunately on the rise. Fifth, planning for changing health and long-term care needs. As we age, healthcare and long-term care become pressing concerns. Integrate your trust with your healthcare directives and powers of attorney, and review your plan for Medicaid eligibility and asset protection. In some cases, converting assets to an irrevocable trust at least 5 years before needing long-term care can help protect those resources from Medicaid spend-down requirements, potentially saving your family $100,000 or more in nursing home costs. Timing is everything. Waiting too long can close the door on these options. Recap and next steps. Let's recap. Next-level trust planning means layering advanced trusts and tax strategies, scaling your plan for multi-generational impact and asset protection, committing to ongoing reviews and legal updates, leveraging technology for security, and integrating your healthcare and long-term care planning. Each of these steps can add significant value, security, and peace of mind for you and your family. The most successful retirees I've worked with never stop optimizing. They stay informed, work with trusted advisors, and adapt their plans as life changes. They understand that trust planning isn't just about documents. It's about building a legacy that endures, regardless of what the future holds. If you've followed this process, you're already ahead of 91% of retirees, and your family will thank you for the clarity, security, and opportunity you've created. But there's always more to learn, more to optimize, and more ways to keep your legacy growing. That's just the beginning, because in our next session, we'll explore how to integrate your trust plan with Social Security optimization, tax-efficient withdrawal strategies, and the latest techniques for maximizing retirement income while minimizing risk. Over the past hour, we've covered a tremendous amount of ground together, delving into the critical world of trust planning that so few retirees truly master. Let's take a moment to acknowledge the value of what you've invested your time in today. This wasn't just another financial video. You've received a comprehensive, high-level financial education, one that represents decades of experience distilled into practical guidance. The knowledge you've gained could easily save your family tens of thousands or even hundreds of thousands of dollars and months or years of needless stress. Let's briefly recap the 8 key insights we explored. 1. Problem identification. We uncovered the shocking reality that only 9% of seniors have the right trust planning in place, and that the average family can lose up to $234,000 to probate, taxes, and legal fees without it. Second core solution. You learned why a properly structured revocable living trust is the gold standard for asset protection, privacy, and seamless wealth transfer. Third practical steps. We walked step by step through the trust creation process, from choosing the right attorney to funding your trust and reviewing it regularly. Common pitfalls. I revealed the most expensive mistakes, like failing to fund your trust, outdated documents, and improper beneficiary designations that can unravel even the best plans. 5. Advanced strategies. We explored sophisticated tools like credit shelter trusts, Q-tips, charitable remainder trusts, and standalone retirement trusts to further maximize your legacy and minimize taxes. 6. Implementation timeline. You now have a clear 90-day roadmap with critical deadlines to turn strategy into action. 7. Troubleshooting. We addressed real-world challenges like uncooperative banks, family disputes, and lost documents, and how to solve them. 8. Next-level optimization. Finally, we discussed scaling your plan with multi-generational trusts, ongoing reviews, leveraging technology, and integrating long-term care planning. This is not just theory. These are the same principles that have helped thousands of retirees across different market cycles. The most successful clients I've worked with consistently apply these principles, and what separates financially secure retirees from those who struggle is usually knowledge and implementation. Now that you understand each piece, here's how they work together to form a comprehensive, integrated strategy. When you combine a properly funded revocable living trust with the right advanced provisions, like credit shelter or charitable trusts, you create a seamless flow for your assets. Your family can bypass the public, expensive, and stressful probate process. Your legacy remains private, your wishes are executed quickly, and your heirs avoid unnecessary taxes and legal battles. Let me emphasize this important point. The compound effect of implementing all these strategies is profound. For example, a retiree with a $1.2 million estate who combines a funded living trust, credit shelter provisions, and tax-smart beneficiary designations can often save $100,000 to $234,000 in taxes and fees, and cut estate settlement time from 18 months to just a few weeks. This is why the wealthiest retirees I advise didn't get there by accident. They follow proven systems, review them regularly, and adapt as laws and family needs change. This is your aha moment. Wealthy retirees often outperform those with more starting capital because they optimize every detail and avoid the silent drains on their legacy. You don't need to be ultra-wealthy to benefit. You just need the right knowledge and the willingness to act. Let's turn this knowledge into action with specific steps you can take in the next 30 days. Step 1. Assessment phase. First week. Start by gathering 3 essential documents: your most recent property deed, current bank investment statements, and all retirement account and insurance beneficiary forms. Calculate your current estate's approximate value using a simple sum of all your major assets. Identify your biggest opportunity area. Is it lack of a trust, outdated documents, or uncoordinated beneficiary designations? Step 2. Planning phase. Second week. Create a personalized timeline based on your age, family situation, and financial goals. Research local estate planning attorneys with at least 10 years of experience and positive reviews from other retirees. Document your current estate plan, if you have one, and compare it to what you've learned today. Make a list of specific questions and priorities for your professional advisor. Step 3. Professional consultation. Third week. Schedule a meeting with a qualified estate planning attorney. Bring your asset list, current documents, and the questions you've prepared. Ask about advanced strategies like credit shelter trusts, QTIPs, or charitable trusts if they fit your situation. Verify that your advisor understands the latest tax laws and can coordinate with your financial and tax professionals. Step 4. Implementation begins. Fourth week. Start by updating or creating your revocable living trust. Fund your trust by retitling your home and major accounts. Don't let this step fall through the cracks. Update all beneficiary designations for retirement accounts and insurance. Set up a secure system for storing your documents and create a simple roadmap for your family. Begin tracking your progress by confirming each asset is properly titled and every form is up to date. Step 5. Ongoing optimization. Schedule a review of your trust and estate plan at least every 3 years or after major life events. Stay informed about changes in tax laws and revisit advanced strategies as your assets grow or your family situation changes. Remember, every financial strategy carries some level of risk, and the goal isn't perfection. It's optimization based on your unique situation. Most successful retirees implement these changes gradually over 6 to 12 months with professional guidance at every step. Don't let perfectionism prevent you from starting with small improvements. The cost of inaction often exceeds the cost of making informed, incremental changes. Let me be clear. These aren't get-rich-quick schemes. They're proven, conservative, long-term strategies that have stood the test of time. You'll know you're on the right track when your financial stress decreases, when you have clear answers to the questions that used to keep you awake at night, and when your confidence in your financial decisions steadily grows. Success is progress, not perfection. Small improvements compound over time. You are now part of a community of informed retirees who refuse to settle for average. The journey to financial optimization is ongoing. Markets change, laws evolve, and new strategies emerge. Continue your education by staying informed about retirement planning developments. Share your success stories and lessons learned with others. Your experience can help fellow retirees avoid costly mistakes and make smarter choices. If this video helped clarify your retirement planning strategy, please give it a thumbs up so others can benefit as well. Share your biggest takeaway in the comments below. Which strategy will you implement first? What surprised you most about the trust planning process? Have you already made any of these changes, or do you have questions about your unique situation? If you could ask a financial advisor one question based on this video, what would it be? Your feedback helps us create even more valuable content for you and your peers. Subscribe for more in-depth retirement planning guidance that could save you thousands in the years ahead. Most importantly, take action on what you've learned. Your future self and your family will thank you for the clarity, security, and peace of mind you've created. Let me emphasize one last time. This has been educational content designed to inform your decision-making. Every individual's financial situation is unique. What works for one person may not be optimal for another. Always consult with qualified financial, tax, and legal professionals before making significant changes. Past performance of any strategy doesn't guarantee future results, and the tax implications we discussed may change based on future legislation. While this information provides a strong foundation, professional guidance is invaluable. A qualified financial advisor can help you customize these strategies for your specific situation. Tax professionals can ensure you're maximizing benefits while staying compliant. Estate planning attorneys can help with the legal aspects we discussed. Imagine the peace of mind that comes from knowing you've optimized every aspect of your retirement finances. Sleep better tonight, knowing you have a clear plan for your financial future. Maintain your independence, protect your family's legacy, and make the most of your hard-earned savings. The sooner you take action, the more time these strategies have to work for you. Don't let another month slip by. Start your trust planning journey today. Thank you for joining me on this important journey. Your legacy and your family's financial security are worth every moment you invest.